Ready, start. We thought that the first appellant would reciprocate by showing grace and accept the apology tendered by the second respondent, who is his colleague in the legal profession. However, the first appellant did not do so and went to the extent of giving a threat to this court that in case this court quashes the FIR registered against the second respondent, he would commit suicide. This conduct amounts to interference with the administration of justice. It is contemptuous and unbecoming of a member of the bar. In the above mentioned case, I was called on 3/3/2025 and I appear virtually and said, double inverted comma, I will commit suicide if the Lordships quashes the case against respondent, double inverted comma close, that upon deep reflection and rethinking, I deeply regret the choice of words used by me. I tender my sincere and unconditional apology to this honorable court for my conduct. I was emotional and with all sincerity had no intention to threaten the judges of suicide. I with all my heart beg to apologize me for this conduct. The Lordships may with all greatness graciously accept my apology, that I solemnly undertake to not to repeat this behavior anywhere before any court, that I humbly request this honorable court to kindly accept my unconditional apology and to graciously pass the suitable order. An attempt made all along by this court was to bring about a settlement between the first appellant and the second respondent, who are members of the bar practicing before the same courts. The reason was that this court felt that both of them, instead of fighting cases against each other, should contribute to the legal system by representing litigants before the court. We felt that the pending cases may adversely affect the professional prospects of both the first appellant and the second respondent. As this court was willing to take a broad view and put an end to the dispute, which has been pending for more than 7 years, the second respondent responded by tendering an unconditional apology to the first appellant. This court was of the view that if ultimately both the cases go for trial, it will lead to more animosity between the first appellant and the second respondent. Pursuant to the appeal made by this court, the second respondent took a reasonable stand and tendered an unconditional apology. However, notwithstanding the best efforts made by the first appellant's own learned counsel, the first appellant did not understand the importance of settling the dispute rather than aggravating the same. He went to the extent of giving a threat to this court. In normal courts, such threats must be taken very seriously by the courts. Action for criminal contempt against the person giving such a threat must be initiated, which should be taken to its logical end, especially when the first appellant is a member of the bar. However, we believe that if magnanimity is to be shown by someone, the same should be done by the persons holding the highest constitutional office.